The year is 1974, and William Carey, a Columbia Law School professor and recent head of the United States Securities and Exchange Commission, stingingly rebukes Delaware as too lenient on corporate directors and too lax in enforcing stockholder rights. He writes that corporate law has to escape from the present predicament in which a pygmy among the 50 states prescribes, interprets, and indeed denigrates national corporate policy as an incentive to encourage incorporation within its borders. Just a little over 10 years later, the Delaware Supreme Court, in Smith versus Van Gorkom, finds that unbiased independent directors are personally liable to stockholders for potentially millions of dollars for approving a deal in which the stockholders get $55 per share for stock that had been trading at $38 per share. Commentators on corporate law are appalled. Atrocious, says one scholar, suggesting that in Van Gorkom, the Delaware Supreme Court exploded a bomb. Another scholar says it's one of the worst decisions in the history of corporate law. William Prickett, the lead lawyer for the plaintiffs, didn't see it that way.
Was that a controversial decision?
Highly controversial, and remains so even today. There are people who really can't abide that decision, and others who regard it as a seminal decision in the evolution of Delaware law.
Right or wrong, the Van Gorkom case has had an enormous impact on corporate law, corporate governance, and practice in mergers and acquisitions. In what follows, we hear from three of the main litigators in the case, who describe in an interview with Joel Freelander of Freelander and Goris how the case unfolded and what its impact has been. A. Gilchrist Sparks III of Morris Nichols Arst and Tunnell, who represents the buyer, the Pritzkers. Robert K. Payson of Potter, Anderson, and Caroon, who represented the directors of TransUnion, the target company, and Michael Hanrahan, Bill Prickett's partner, who represented the stockholder plaintiffs. We first hear from them about how the challenged acquisition of TransUnion came about. The core business of TransUnion was leasing rail cars.
Bob, I think you mentioned that there was a tax component to the deal, and the structure that, in the sense that the company had certain tax benefits that it was taking advantage of. Is that right?
In connection with their rail car leasing activities, there were certain tax benefits from that business, and the board had become concerned as far back as a study that was done a couple of years before that Congress was going to pass legislation which would make that would create tax problems, and that the benefits that they then had would go away. And that's why Van Gorkom seemed to be in a rush, although I don't think he was, to sell the company immediately to get the highest price possible before Congress did something that would harm the value of the stock.
Right. Now, did you have a sense of like the time frame involved, until any potential legislation happened, or this tax effect would manifest
My recollection
itself?
is that at least some of the directors thought it was imminent, and that's why they pushed forward.
Right. But the idea was the company could be sold to somebody else who could better take advantage of the tax benefits?
Correct, yes.
I thought that we had built a pretty reasonable case in terms of the knowledge and sophistication of the directors who sat at that Saturday board meeting, and who had recently, very recently before this, been subjected to a complete study of the company by the Boston Consulting Group. They understood the business dynamic that would cause this merger to be advisable, in the sense that they had a lot of tax loss carry forwards. They didn't have enough operating income to take full advantage of them, and that, in a sort of perverse way, was causing a burden on their stock. So they couldn't buy little companies fast enough and manage them to take care of that problem. So that the idea of selling the company was something that had at least surfaced by the time they reached that Saturday meeting.
The members of TransUnion's board of directors, which would have to approve any sale of the company, were apparently all sophisticated businessmen who were considerably familiar with each other.
Tell us about the outsiders.
Well, the outsiders were all very accomplished people. They were all, I think every one of them had been a CEO somewhere, and pretty much a CEO in the Chicago area. So it was the CEO of Swift, the CEO of Railway Express, the CEO of U.S. Gypsum. On a lot of these companies, IC Industries, that IC used to stand for Illinois Central. So these were all people who knew each other, sat on each other's boards, and it was particularly in that time seemed to be true of the Chicago area. There was more of this sort of, I don't know if inbreeding is the right word, but there was more of CEOs sitting on other CEOs' board in the same community out of the Chicago area than would have been the case in New York or Los Angeles or Houston or some of the other corporate centers at the time.
So among the outsiders, how well would you say they knew each other or interacted?
I think they knew each other really well, and most of them have been on this board for some period of time, which, as you read the case, was part of the defense, that they knew this company really well.
Did you form any impressions of how this company operated or about the directors when you went out there?
It seemed to me that Mr. Van Gorkom was in charge, although he wasn't beating people over the head to get things done. I was impressed with the directors generally, especially the outside directors.
Mm-hmm. Can you tell me something about the outside directors, like who they were? Or?
Bill Johnson was the chairman of IC Industries, extremely bright, knew about mergers and acquisitions. The same for, I think it was the chairman of Swift and Company, and Bob, can't remember his name. But all of the outside directors seemed to have a lot of experience running corporations and valuing companies in the context of takeovers and mergers and acquisitions.
Mm-hmm. Can you give me a sense about their backgrounds? What kind of people were on the constituted the board?
I'm not sure I knew at that time what their educational background was, but they all appeared to be bright people.
Right. And were they all from Chicago, or in terms of like the social circles of them? Did you have a sense of that?
I had the sense that there was a social circle among the directors. They knew each other socially, but more importantly, they knew each other from serving on each other's boards.
But to the stockholders' plaintiffs, the quality of the directors' resumes wasn't enough.
Yeah, and it's interesting when you go back and look at things, because a lot of the defense was based on, these directors were people who had been CEOs of companies, and they were solid citizens, and Van Gorkom had been at the company for 25 years, and so the emphasis on that side was, well, all you had to have was a collection of very qualified directors and some managers who were experienced with the company. But the specific issue was the decision to sell the company. And that was not something that Van Gorkom had never done a transaction of this size, and the others really hadn't. And I think Bill's view was that you had to not just be competent, you actually had to bring that competence to bear on the particular decision and have the information that was necessary. And for example, he felt that Van Gorkom may have known a lot about the company, but he really didn't know what the company was worth as a whole, which is a different thing than knowing the individual parts.
At the center of this merger was TransUnion's CEO, Jerome Van Gorkom.
Tell me any impressions you formed about Van Gorkom, just seeing him at the offices or anything, just how he ran the company as far as you could tell.
So Van Gorkom was, and again, this is sort of a reflection of the times, but Van Gorkom is what you would have, in my view, thought of as the 1970s imperial CEO. He looked the part. They had in the offices, they had red carpets in the executive suite, and only people who were officers of the company and their admins were supposed to walk on those carpets without permission. I can remember one time when I was at the office, and I was summoned by Mr. Van Gorkom with a sort of Sparks. My own client wouldn't have done that, but as far as he was concerned, I was somehow on the subordinate side of the picture, and I felt like he dealt with his own executives pretty much the same way. He had been CEO for 17 years, which was a long time, and successful. And but the other personality trait that I sort of sensed in him was a very puritanical one. And I don't mean that to be necessarily negative. I think it was, but in some sense, a positive.
And when you said you got the impression that Van Gorkom was in charge, can you tell me what you mean by that?
Well, he was the CEO, and he acted like a CEO. I mean, he was in control.
Now, there also on the board were several of his was lieutenants, other officers of the company, correct?
Right.
So, when you say he acted like the CEO in relation to his board, I don't know, what do you mean? Can you give us like a sense of how boards operated then, or how this board seemed to operate then?
He did not appear to me to be heavy-handed, but you could tell when he spoke, people paid attention, including the members of management who were on the board.
And I think you're talking about how Van Gorkom ruled, like he was clearly the guy in charge. Was there something about the carpeting of the offices that reflected that?
I have a very vague recollection of a carpet with lines on it, and only senior people could walk on some lines, and others had to walk on other lines. And I also remember a bottle in the refrigerator in the kitchen where it said Van Gorkom's do not touch. That's my recollection.
Right.
But I will tell you, I became very fond of him when I was preparing him for trial. He impressed me as being very, very honest and cared for the shareholders and wanted to do his best for them.
Consistent with being a take-charge guy, Mr. Van Gorkom basically negotiated the deal himself and did not involve the board of directors.
Now, can you just describe generally what was your understanding about how the deal had been put together, what the negotiations had been?
My early understanding was that Van Gorkom had done a study on his own and had come up with a number. He used the company's cash flow to go to Pritzker and said, Jay, if you want to do this deal at $55 a share, the cash flow of the company will pay for the deal in 5 years.
And what happened, and how quickly after that did the deal come about?
It happened very quickly. I think Jay took a look at it, probably with some of his own people, and said, sounds like a fair deal to me, and then made an offer.
Okay, and so how many days later was that?
I'm thinking a week.
Okay, and then and then Van Gorkom brings Mr. Pritzker's offer to the board. Is that right?
Right.
And on a Saturday, right? Is that right? Or
I believe that's right.
okay, and the board meets to decide whether to sell the company at that time. Is that right?
I think the meeting lasted 2 hours, and they considered it and said, this is the best we can do for our shareholders.
Now, when did the outside directors or even the inside directors first learn about the transaction, or about the proposed transaction?
At the board meeting on...
At first board meeting September 20th.
Right.
Okay.
Right.
And what?
Now, I think Van Gorkom had shared what he had done as far as negotiating with Jay with at least one other inside director.
Okay.
But the whole board did not have that same knowledge.
And that fact eventually resulted in harsh questioning by Justice Andrew G.T. Moore II of the Delaware Supreme Court.
We suspected that Justice Moore was trying to revisit some settled Delaware law, but of course we didn't know that.
All right. Now he gave you a bit of a hard time at oral argument in going back to the spring of '83. In terms of the fact that Van Gorkom didn't tell his fellow directors before the board meeting that I have solicited and obtained an offer to buy the company for $55 a share. Right? He says, now it doesn't speak well, in my opinion, for a former chief executive officer, for a chief executive officer and chairman of a board to say he doesn't trust his board and that he wouldn't tell them because he was fearful that something was going to get out on the street. Now that is the record, isn't it? And you said Mr. Van Gorkom was concerned about leaks before he got a firm offer. What was the testimony? What was Mr. Van Gorkom's view on that?
As I recall, he simply said that the more people that know, the more chance there is for a leak, and the leak could blow a great deal. I've never understood quite how that would happen, but that was certainly Van Gorkom's view.
The directors weren't the only ones with no advanced warning of the deal. Outside counsel wasn't brought in until the day before the board approved the merger.
So the idea that the outside counsel was retained the day before the merger agreement, did that strike you at the time as a problematic thing?
Yes, I think that was problematic. It certainly, as you read the opinion, became problematic, but it was sort of worse than that in that there was no effective assistance of counsel, whether inside counsel or outside counsel on the TransUnion side, up until the day of the board meeting. So what was brought to the board didn't really have the input in any material way of any counsel.
The Supreme Court also didn't like the way the original merger agreement was approved. The merger agreement was executed by Van Gorkom during the evening of September 20th at a formal social event that he hosted for the opening of the Chicago Lyric Opera. Neither he nor any other director read the agreement prior to its signing and delivery to Pritzker. In fact, there was apparent confusion in the boardroom about the legal impact of the board's approval of the merger agreement.
Well, there's an amendment to it. There's an amendment to it that's made that day on Saturday, the 20th, which is, and this became a subject of a lot of litigation, that the board didn't like an aspect of the deal, that there was some sort of understanding that Gorkom had that this deal would be shopped or that it would be operated as a floor.
Right, so there are a couple of things going on here. The fact-finding in the opinion, and I can't quarrel with it, I haven't gone back to see what Van Gorkom's testimony was, but I don't doubt it. Mm-hmm. Van Gorkom apparently was operating from a false legal premise in one sense. It's, in my view, it's always been the law that you can't trump a contractual duty with a fiduciary duty. So you can have what we would call today a fiduciary out, but you better write it in your merger agreement. You can't simply say, I have fiduciary duties and therefore I can ignore this provision in the merger agreement that says that I can't shop the company.
Or they have to recommend it to the stockholders.
Or have to recommend it to stockholders or something like that. So those things, and of course under the common practice today, all those things are part of the contract, and there are many of them are heavily negotiated as these deals are done. But back then, the law wasn't. Well, it hadn't made it to Van Gorkom, and I know I had written an article about this, but maybe I wrote it afterwards. I can't remember. But I know I always had the view, but I'm not sure it was shared by everyone, that you cannot trump a contractual duty with a fiduciary duty. So Van Gorkom goes into this apparently thinking, well, I can. So there were some fundamental legal misapprehensions that appeared to be around in the thinking of some of those who were part of the September 20 meeting, perhaps innocently. But one of them is you can approve a merger agreement without necessarily recommending it, and just let the shareholders decide. And I think we've discussed a couple of the other ones, the idea that you could trump, a fiduciary duty could trump a contractual obligation with a third party. You could invoke your fiduciary duty and somehow avoid a commitment that you had made in the contract that was wrong. And so and then you can ask yourself, well, and would, if there had been, if counsel had been retained at even a week earlier to help out with this, maybe people would have been told that was wrong, but neither in-house counsel nor outside counsel were consulted before the day of the board meeting, so, or the day before the board meeting. So you'll never know the answer to those questions.
Maybe those questions wouldn't have mattered if Mr. Van Gorkom and Mr. Pritzker, who negotiated the deal, were equally experienced in such negotiations. But there's a suggestion that there was a mismatch in terms of that experience.
Again, just in terms of the part of the dynamic of this deal, you had you had Van Gorkom, who's exploring a sale and doing it sort of on his own, pretty much.
Pretty much, yeah.
And the person he approaches is Jay Pritzker.
Right.
And what's the merger and acquisition sophistication on the Pritzker side of the table?
Well, the Pritzkers were about as sophisticated in terms of buying companies, putting together a corporate empire through mergers and acquisitions as anyone at that point in time in our history. I mean, the Pritzkers put together the Hyatt chain of hotels from literally nothing. They had another entity called Hyatt International, which put together an international chain of Hyatt hotels. They had TransUnion, which was had been acquiring companies. I'm sorry, they had GL, which had other companies that were in its umbrella that they had put together, and so this was sort of old hat to the Pritzkers, and obviously was something that at this magnitude Van Gorkom hadn't really done before. While they had acquired some smaller companies, they had never done anything like this before.
There may have been a mismatch on the legal experience side, too, because the Pritzker side was represented by Hank Handelsman, formerly with the Wachtell-Lipton firm in New York.
And did you have a sense there was like a disparity of sophistication and say just corporate talent and advice about between the Pritzker side versus the TransUnion side?
Well, I knew Hank Handelsman. Hank was an extremely smart corporate lawyer with trained at Wachtell, so he had a great sense of how to do this, and there was just nobody but Van Gorkom on the other side.
The plaintiffs have their duty of care argument and all the facts about the care, and Prickett's telling this factual story, and there's a question of whether is there what the roles are and how to characterize Van Gorkom, who he says is a very foolish man. He says they think he was taken advantage of by Pritzker, and just trying to tell a story about how this deal came about and why it's wrong.
Yeah, and it's consistent with the idea that Jay Pritzker knew how to buy companies. He'd done it numerous times before, but so Van Gorkom, compared to him, was an amateur.
So the plaintiffs eventually characterized Mr. Van Gorkom as a foolish man nearing retirement, for whom selling the company would be a personal legacy.
Well, let me put it differently. What did you have a perception of Van Gorkom's motives, why he did what he did, and in terms of selling the case, either at the pre-injunction stage or at, say, a trial? Did you form an impression?
Over time, I would not completely reject, even though it wasn't part of the case, it wasn't a duty of loyalty case, but I would not completely reject the concept that as Van Gorkom neared retirement age, given his personality, he preferred to cash out and sell the company rather than turn it over to any of the people who were his subordinates. You can never prove that, and that's not the way Prickett, even though he made noises about that, sought to prove it. but it's not a completely implausible motivation, if you will.
Plaintiff's lawyer Bill Prickett definitely made such noises.
He says about Van Gorkom, I don't suggest that he's a villain. I suggest he's a very foolish man who does a thing so hastily and so ill-conceived, panicking, as he obviously did, that the Young Turks were going to replace the old man who had dominated the company so long. You know? So he had this, his motivational story, but it's not a classic self-interest story as applied to Van Gorkom.
Well, sometimes courts recognize people are maybe motivated by other than financial factors, and Bill always stressed that Van Gorkom was coming to the end of the line, and that this sale of the company would be sort of the crowning accomplishment of his career. But the real question was it the right time to sell this company?
Right.
And he kind of made that decision pretty much on his own.
But the original stockholder complaint, filed on December 19, 1980, didn't focus on a personal desire to sell the company, getting ahead of the board of directors, or getting out-negotiated.
In December of 1980, I think it was December 17th actually, Bill Prickett was contacted by some lawyers from the Shank-Irwin firm who in Texas, who represented Alden Smith, who had been a stockholder of TransUnion. That's how the case began for us. The initial complaint was filed only 2 days later on December 19. There are some interesting claims in that complaint, and a lot of that stemmed from the fact that a good part of the complaint was drafted by the Texas lawyers who really weren't that familiar with Delaware practice.
Okay. And also, yeah, right. And also Alden Smith, he had a unique stockholder position in the case, and sort of maybe a unique interest in what bothered him about this transaction, the sale of TransUnion.
Yeah, there was a heavy focus on tax treatment because he had gotten his stock in TransUnion in a stock-for-stock merger where his company had been acquired, and so one of the major effects for him was that because it was a $55 cash price, he was going to have a huge tax bill. So that was an early focus of the case, but really later on it shifted to more the due care aspect and disclosure aspect.
When we first heard about the case, we had the allegations of the complaint. The allegations of the complaint obviously didn't have all this detail because the plaintiff didn't have all the detail in hand. In fact, the thrust of the complaint was largely different than what it turned out to be in the end. The thrust of the complaint was that the two stockholders who brought it, who were large stockholders, they had one of them I think had 54,000 shares, the other had 30,000 or something like that, and they had gotten their shares in some sort of tax-free exchange, and they were mostly upset about the fact that this was a cash-out transaction, and they were going to have to pay a substantial amount of money to the federal government as a result of the cash out. And that was the main thrust of the complaint, and it was sort of the board didn't think about us, those of us who have low basis stock, which would have been acquired in connection with acquisitions that TransUnion had made over the years of other companies.
But the case quickly evolved to focus on the care exercised by TransUnion's directors.
So let's step back and think about what the status of the law is on what this case ultimately got decided on, which was a breach of the duty of care in terms of informing yourself prior to making a decision. Prior to this case, I don't believe there were any cases, other than cases involving a few scattered cases involving banks, where directors back in that time were thought to have some higher level of fiduciary duty than directors of run-of-the-mill manufacturing companies or other types of companies. And there were a few scattered cases, I'm not sure there were any in Delaware, that talked about gross negligence and the fact that maybe you wouldn't get the business judgment rule if you were grossly negligent in considering a matter. So this was new ground, and while there had been a lot of writing in the 70s about the parameters of the business judgment rule, it just really hadn't ever quite made it to the court system in Delaware yet, in terms of the possibility that you might be liable, personally liable for money damages for something other than a breach of the duty of loyalty or bad faith.
In response to the complaint, and with input from Delaware counsel, TransUnion and its directors took several steps to cure any possible deficiency in the board's original approval of the merger.
The proxy statement was an attempt to sort of take all the bad facts that had been developed in the depositions, all the questionable facts, all the things we've been talking about. Van Gorkom, in effect, gave the $55 price to the Pritzkers, that there was only a day or two notice of the board meeting, that they didn't have the merger agreement. All of those things, there was an attempt to put all of that into the proxy statement, as well as the failure of the GE deal and the failure of the KKR deal. And the reason for that was, all right, somebody's challenging us. There are two reasons for it. Number one, we had disclosure claims both in the Prickett complaint and in the Ridings complaint in Illinois. And so how do you beat a disclosure claim? Well, you just disclose everything you can think of. And number two, you have a board that, and this is getting into this in a bit in the opinion, but to the extent the board had any ability to change its recommendation or to otherwise get out of this deal, here was a chance for them to look at it all again with as many facts, with all of these facts that had now been developed in the litigation before them. So the idea is you get all this, you beat the disclosure claim, and you also allow the board to exercise its business judgment and take advantage of the case law that allows you to ratify things.
And it comes out in the depositions about, facts about, how the directors had just learned about the transaction. Romans was either opposed to it or thought there was more money available. And as a litigator, there are a couple things that were done on the defense side. Can you describe for them in terms of at the board level and in terms of informing the stockholders?
Well, at some point, the proxy statement went out with respect to the deal as originally cast. We then thought it would be important in defending the litigation to cure any of the allegations of the complaint. So we issued a supplemental proxy statement and threw everything in, including all the allegations of the complaint. So we thought the shareholders had full information upon which to make a decision.
Okay. Now, there was also something done at the board level. So there's a January 26th board meeting, and the board is asked to adopt or review a whole series of resolutions about facts of the case to consider the transaction again. Is that right?
Correct.
Now, what was the rationale behind that?
Once again, it was to put everything in front of the shareholders, and if they voted in favor of the deal, that would be it.
The they being the shareholders.
The shareholders, right?
Okay. But the board did now. And what do you have a sense about what the significance of that was from a legal perspective if the stockholders voted in favor of the deal?
It certainly was my view, and I think shared by Gil, that if the stockholders had all available information and voted in favor of the transaction, that would moot the complaint.
Well, I think you could see from the strategy that was employed, including the effort in January to in effect bring the board's attention to all of these facts, certainly the defense lawyers were uncomfortable with standing on what happened as on September 20th as being the record, and did want to bring this matter back to the board on multiple occasions to make sure that the board was kept apprised of developments as they went forward. And I think this. And we were concerned about the disclosure claims, and that's why all of that was laid out in the proxy statement. And I also think that the October 10 sort of opening this thing up to a go shop was
The October 10th.
yeah, it was significant. And I suppose if there was an area of greatest disappointment in terms of the way the Supreme Court handled it, it was sort of the way the Supreme Court blew that off, I guess is the way I would put it, and said it didn't count.
Now, I think there's a line in the briefs in the chancery phase where it says, well, maybe speaking to that about the effect of shopping the company, it says, well, as we've just seen with Conoco, with DuPont, Seagram's, Mobil all bidding for Conoco, that there's an active market for companies, and therefore if you open up the process, that should be good enough. Did you think that was sort of basically a winning argument at the time?
It was a positive argument. The idea that the basic idea, which I think to this day is sort of true, is if you put it out there and somebody's really interested, they're going to find a way to make an offer and push forward.
With this background, the claims in the case faced a lot of skepticism at the outset from the corporate bar.
From a Delaware law perspective, did you have a view about whether this made this a hard case or an easy case, or what was your view coming in?
We thought it was a classic business judgment rule case. None of the directors was interested in the transaction. So we thought the business judgment rule applied, and we also thought that the directors, because of the study done within 2 years of the merger, that they were informed. They knew what they were doing.
Were you at the Potter offices or something, and one of Prickett's former partners showed up or something?
Yeah, Rod Ward was in Charlie Crompton's office, and I went in, and there was a copy of Mr. Prickett's complaint on Charlie's desk. I had probably given it to him, and Rod said, "That's why I left to go to Skadden," and pointed to the complaint.
What'd you understand that to mean?
That he thought it was frivolous.
I see. And was that your view as well?
Well, I'm not sure I thought it was frivolous, but we thought we would prevail.
Throughout the proceedings in the Court of Chancery in front of Chancellor William Marvel, the outlook for the stockholder plaintiffs didn't get any better.
Now, the case went to start off with a preliminary injunction hearing, right?
Right.
How'd you feel about the case at that stage of the litigation?
We thought we were in a very solid position based on Delaware law and the business judgment rule.
Okay.
And the fact that we met all the directors and they all appeared to be honest and not involved in the deal at all.
There's a statement at the oral argument by one of the lawyers on the defense side by Gil Sparks, saying, "Your Honor, this is an arm's length merger. We've looked through the cases. We haven't found a case in which this court has enjoined an arm's length merger. And of course, in this type of case, plaintiff must show constructive fraud to prevail." Was that?
That was our view of the law, yeah.
And so that an injunction was, you don't think was going to happen? Is that fair to say?
We thought we had a very solid case.
Now, do you have any sense that this was a momentous case, an important case, at any point during the chancery stage?
No, we thought it was a classic business judgment rule case, and that we had no problems. The directors had no problems.
And your side was taking the view that gross negligence was the standard, right? And did you have doubts at all that the kind of facts you had would or would not meet the test of gross negligence?
We were confident that there was no evidence of gross negligence.
But the plaintiff's lawyers, led by Bill Prickett, didn't give up.
Oh, Bill, always believed that the law is that which is boldly asserted and stoutly maintained. And he felt that, and Bill was very much a trial lawyer, and I think what really intrigued him was not so much the corporate law principles as the factual record, and how, in his view, how badly the board had performed, particularly in the first meeting, and then the second meeting, and then with the help of Bob Payson and Gil Sparks, they tried to go back and fix it, and I think they could, at least to the majority of the Supreme Court, they never fixed it to the satisfaction of the court, and certainly not to Bill's satisfaction.
Right.
And I think, and then even when you had two of the best Delaware corporate lawyers involved, and they tried to fix it, but I think they could never sort of overcome the problem that it had been messed up initially, and any effort to fix it sort of suffers from a credibility problem, because now the same directors are claiming, oh well, now we looked at it more carefully and we come to the same conclusion, but it's a little hard to convince a court that they're not just basically covering for themselves.
One thing that really comes through, well, I mean, I'm thinking like the preliminary injunction oral argument is really striking. To get a sense of, I'd say unorthodox, but maybe a better adjective would be like theatrical and dramatic. Bill Prickett was how he couched his oral argument, where he. The way he made it right from the get-go is he said, I was trying to figure out what to say to the court this morning when a stockholder called me up last night and asked me about the case, so I told him about it. And then the argument consists of just dozens and dozens of pages of then, so I told him the facts of the case, and then the stockholder asked me this, and I answered that, and the stockholder has all these follow-up questions. Well, how can that be? How can that be? It just reads like a bit of a play.
Bill could tell a good story, and I mean, in a way, he ultimately that's what was successful is the story of how did Van Gorkom and Pritzker reach a deal? What did the board know and not know? And that was Bill. I was struck in one of the Supreme Court arguments. He starts out by telling the court things that he's not going to discuss,
right.
and the Chief Justice Herman says, so like Cicero,
right.
You're telling us what you're not going to say. And Bill then responds, and now like Plato, I will tell you what I am going to argue. So that was just Bill. He had a way.
I think Bill Marvel had a couple of classical allusions in sort of his remarks from the bench looking back at these arguments.
Oh, yeah, the Chancellor was again, these were sort of Renaissance men, and they would make these classical references, and Bill was always entertaining, and he just had a series of phrases, and could also just come up with things on the spot.
So that process was so long, from losing the preliminary injunction hearing at the end of January, in February 1981, losing a trial, and then, being all the supplemental briefing and the multiple arguments in the Delaware Supreme Court, and that takes you to 1985. Was there ever a lack of confidence in the case, or a feeling like, oh my gosh, what have we gotten ourselves into?
Well, with Bill, it's always full speed ahead, so he had confidence in the case. And it's, you either give up or you play it out. Mm-hmm. And Bill, in both Smith v. Van Gorkom, but also Weinberger v. UOP, which followed a similar course,
right.
losing
Spanning
losing
the
below.
same years, yeah.
Well, somewhat, but I think the Supreme Court's opinion in Weinberger came out in '83, and that's, while it was a different context, it certainly gave some hope, and there were I think trends developing, but you didn't know, and there are other things where the initial hearing was in front of the Chief Justice Herman, Justice Moore, and Justice McNeely, and then it went en banc, and so you had a sense that at least there was probably one justice who may not agree with the Chancellor's opinion. So you didn't lose hope entirely, but still you felt like you were swimming upstream.
And the plaintiffs did a lot of swimming against the stream. But litigation was different in the early 1980s than it is today.
And you also have to remember, going back to that time, the amount of information that was available publicly was very limited. You didn't have an internet. You didn't have Edgar, where you could go and readily look at the various SEC filings. Now, there were particular SEC filings that had been obtained, and they're referenced in the complaint. But your universe of information starting out was much less than what you'd have in evaluating a case today. And you were much more dependent on getting discovery. Right. And the discovery was much more limited than it would be today. Bill sometimes invented funny documents, but he
What do you mean by that?
He put into the record in Smith v. Van Gorkom a list of all the documents that had been produced by the Pritzker Group. It was like 174 documents, and then TransUnion, and it was like 150 something documents, and that was basically your discovery universe. And then you took depositions. Today, of course, with electronic discovery, you'd have so much more information, and I think it would make it easier to make the case out because you'd have emails with the directors. Sure. And what have you. So you had to go along and then try to develop the story much more through depositions than might have been the case today.
Right. I guess unless you had people that kept their handwritten notes, you're really at a disadvantage for what they're thinking contemporaneously. Right?
That's right.
Even with discovery information in hand, Chancellor Marvel declined to grant a preliminary injunction preventing the merger from proceeding, but the plaintiffs still didn't give up.
Now, what did you think would happen to the case at that point?
Well, knowing Bill Prickett, it probably didn't matter if we won or if we won, because he would be coming back. I had had experience with him in the Weinberger case, and Bill does not give up. So we were hopeful that the denial of the preliminary injunction would put an end to the case, but it didn't.
Okay. And indeed, the case marched forward to trial just for the next few months after that, right?
Prickett pushed very hard for an expedited trial.
Was there any availability to sort of like end the case, or by motions or?
No, we thought that the opinion on the preliminary injunction really put an end to the case, but it wasn't dispositive. There was still a case out there.
At trial, the defendants were pleased with how their witnesses' testimony came in.
I called Van Gorkom and Bill Johnson, and I thought they came across very, very well. In fact, the judge's law clerk, after Van Gorkom testified, came up to me and said, "Where did you get him? Central Casting?" Which was interesting. She thought he was a really good witness, as did I.
It's sort of funny to hear that from the law clerk in the middle of the trial or after the trial.
In the middle of the trial.
Yeah.
It's a small town.
Yeah.
In fact, she was the wife of one of my partners, former wife of one of my partners.
Okay. So you prevail, as I guess as expected, in the Court of Chancery. And did you have a view about how the case looked then, for purposes of appeal?
We thought it should go away, but once again, Bill Prickett, in his dogged way, kept coming and went to the Supreme Court.
Mm-hmm.
It was really only on appeal that the defendants began to have some real concerns about the outcome.
Under Delaware practice as it then existed, when you made an argument to a 3-judge panel and you're called back for a re-argument en banc, under the rules of the court at that time, that meant that one of the judges was against you. So it was, at that point, you were dealing with a 2-to-1 case, and you didn't know if you had the 2 or if you had the 1. And from that point on, there isn't any question that you're worried about the case. Mm-hmm. I mean, and then to have multiple re-arguments en banc, and to have this huge amount of time between these arguments, you know that something's going on, and that there's a lot of things are being discussed and mulled over, and your confidence in how it's going to come out it cannot be at the same level that it was before all of that started.
I think this is the second argument. The May 83. Justice Moore says, now it doesn't speak well, in my opinion, for a CEO and chairman of the board to say he doesn't trust his board, wouldn't tell them, was fearful it was going to get out on the street. Was that in the record? And Payson says, well, Mr. Van Gorkom is concerned about leaks. And Justice Moore says, don't you think if directors are going to be viewed with such cynicism, there really is something really very wrong here, and maybe the business judgment rule shouldn't apply? But it seems to me that's a terribly cynical bit of testimony. And he says, talking about selling the whole company, don't you think there's something that's something the board ought to know about? I guess pretty strong signals from him that he's not happy about how the record looks, at least as of September 20th.
I think that's right.
Yeah.
In fact, plaintiff's appeal strategy focused on creating a concern that Chancellor Marvel didn't get the facts right.
Mike, I was wondering if you could tell me anything about the appeal strategy that Bill Prickett had.
The thing I remember most is that Bill felt that the Chancellor had not gotten certain facts correct, and that one of his strategies on appeal was to first try to convince the Supreme Court that there really were factual errors in the Chancellor's post-trial opinion, and that was the first argument in the appeal brief was on factual matters, which is a little bit unusual as an appeal strategy. And then it went into the due care argument and the other arguments. And that was, again, I think stemmed from Bill's belief that the facts should really drive the case. And if you saw the facts correctly, then you'd reach the conclusion that the board had not made an informed and careful judgment.
There was even a suggestion that the Supreme Court felt the Chancellor hadn't reviewed the deposition testimony.
Without ascribing it to any particular justice, I was told at some point by one of the justices that one of the important reasons why the case ended up as it did is that the sealed deposition transcripts, which were sealed for confidentiality, were in sealed envelopes in the court's file, and that those sealed envelopes had never been opened. And the inference that was apparently drawn from that is an unhelpful one when you're trying to rely on the very favorable Levitt versus Bouvier standard of review in Delaware, which basically says that if it's a fact-finding question, as distinguished from a legal question, the Supreme Court won't interfere with it unless it's not the product of a rational decision-making, logical decision-making process. And if the court, if the Supreme Court is of the belief that the that portions of the record that the Supreme Court deemed important were not read by the judge below, then you're obviously at greater risk under that standard of review. And if you read the Supreme Court opinion, you will see that on a couple of times, they, without getting into detail, they make it clear that because of the record below, they feel free to do fact-finding on their own, as distinguished from, in effect, reviewing the fact-finding of the court below.
When the Supreme Court opinion finally came out, nearly 5 years after the merger, and in a rare 3-2 decision, the defendants were, not surprisingly, disappointed.
Now, famously, the decision comes out, and it's a 3-2 decision in January 1985.
It was not a happy day.
Do you remember anything about that?
Not really. Just being very disappointed
Yeah.
and shocked.
Can you give me your sense of what your thoughts were about the case as reflected in your motion for re-argument?
Well, we thought that the majority opinion was just clearly wrong, and I tried to spell that out in the motion for re-argument, and it was kind of a no-holds-barred piece of paper. Respectful, but judges, you didn't quite get this right, and here's why.
It was a big deal, and the idea that honest directors of this caliber could be personally liable based on a court's finding that they had been negligent or grossly negligent was a wake-up call to corporate America.
In their motion for re-argument, defendants said, "The majority opinion of January 29, 1985 has shocked the corporate world in its unprecedented holding that knowledgeable directors of a Delaware corporation performing their statutory managerial function may be exposed to catastrophic personal liability with respect to an arm's-length business decision where there were no charges or proof of fraud, bad faith, or self-dealing." Of course, the plaintiff's lead lawyer saw it very differently.
I wrote a law review article pointing out that it was not as revolutionary as the people who were against it seemed to paint, that it was a natural evolution of Delaware law and fitted in quite well with principles of Delaware law. And it has turned out to be that, and it is widely quoted now.
In any case, the motion for re-argument was denied, followed by a very unusual court appearance.
Can you tell me anything happened? Anything you heard about the case after it came out, or any interaction you had with the court afterwards?
Yeah, quite surprisingly, very shortly after the opinion came down denying the motion for re-argument, the lawyers were summoned to Supreme Court chambers, I think by the clerk of the court, but I'm not sure. So Bill Prickett, Gil Sparks, and I traipsed over to court, walked into chambers, and Chief Justice Herman said, "Gentlemen, there's a rumor going around that this court was once 5-0 to affirmance and that one judge turned the court around." He said, "The first part of that rumor is true. The second part is not. You may use this information as you see fit." And we kind of looked at each other dumbfounded and walked out. It was an interesting end to quite a case.
Settlement of the case followed soon after that.
Ultimately, Bill concluded that if you were going to settle the case, you really had to settle it with Jay Pritzker.
Well, let's talk about that, because one of the, I guess, great dynamics of the case, or about the lawyering of the case, is Bill Prickett developed this relationship with Pritzker. Isn't that the case? Or
Yep.
Can you just talk about that? Or,
The two really came to like each other, and remember that when Bill went out to Chicago one time, and I think it was for depositions in the case, and Jay Pritzker asked him where he was staying, and Mr. Pritzker wasn't real impressed with the hotel and said, next time you come out, let me know and I'll get you a room. He was just a very gracious man. Ultimately, one of the things that may have helped was that after trial, Bill actually dismissed Pritzker from the case. Below the opinions are Smith v. Pritzker.
Well, the complaint is right. It's Smith versus Pritzker. Right. It's the lead
and Bill's feeling was that at the end of the day, with all the discovery and all that, Pritzker was just a very smart businessman who saw an opportunity and he took it. And I think that may have been helpful later on when he was the guy you had to settle with. And Jay Pritzker was always very complimentary of Bill, and he said, "Oh, you took this nothing case and you turned it into, you convinced the majority of the Delaware Supreme Court to go along with you." And then it ended up that for years thereafter, Bill and the Prickett firm ended up doing work for Jay Pritzker, and that arose out of the relationship that developed from Smith v. Van Gorkom, and it was basically the two of them who really settled the case. Initially there was a meeting with some of the directors, and then Bill really concluded that if you were going to get this case settled, you needed to settle it with Jay Pritzker. But he was concerned because Mr. Pritzker had some heart problems, and Bill was actually concerned that, well, will he be around? So there was a real interest in getting a settlement done. And back then, Bill was insistent on driving to New York all the time. And one of the things I ran across was New Jersey Turnpike receipt from, I remember going up with Bill and Jim Holzman, and Bill had this old diesel Mercedes, and he kept cans of diesel fuel in the car and driving up and back. And by the time we got back, Jim Holzman and I had decided we were not going on another trip like that because we both had headaches from the fumes.
The case was eventually settled for $23.5 million in cash, drawing in part on a $10 million directors' and officers' liability insurance policy.
So one of the things I just remember very clearly was I was assigned to go up to D'Amato and Lynch, which is the insurer for the directors and officers. By this time, we owned the company. We owned the company, and my job was to persuade them to hand me a check for $10 million, which was the total amount of the D&O insurance that was available. And I had this great speech for them. I maybe even started to make it, and it went like this. It was, there are lots of outs in D&O policies, but there's no out for this. I said, there are outs for breaches of the duty of loyalty, conflicts of interest, and the like, but this is a pure gross negligence case, and the Supreme Court says that there's no bad faith or duty of loyalty involved. I said, this is the D&O insurer's nightmare. And somewhere in the middle of that speech, the guy reaches into his desk and hands me a check for $10 million. And I get back on what was then the Metroliner, and I come back home. So that was an easy part of the case.
The rest of the settlement money was more complicated. It wasn't clear that the Delaware statute, Section 145, would permit TransUnion, now owned by the Pritzkers, to indemnify its directors to fund a settlement of a case in which they had been found to have been grossly negligent.
The other $13 million raised an interesting indemnification question. Our indemnification statute, for those who aren't completely familiar with it, basically says that you can indemnify somebody, a director, if he or she reasonably believe that their actions were taken in the best interests of the corporation. And the interesting question here with this type of case was that you could certainly look at the Supreme Court's opinion and said, well, the the Supreme Court has basically said that they were ill-advised, that they didn't reasonably make a judgment that this
grossly
was
negligently.
Yeah. So how do you match that up with our statute? And what was at stake there was whether or not the company indemnified the directors, or whether the Pritzkers, in effect, who owned the company, said, no, you don't meet the standard, and we litigated on for many more years while the individual directors' personal estates were at risk. And in the end, Jay Pritzker stepped up, and the company, which he now wholly owned, paid the $13 million, but required that the individual defendants all make substantial contributions. I don't know if they matched $13 million, but make substantial contributions to charities of Mr. Pritzker's choice.
And there's something to that choice, isn't there?
Well, yeah. I mean, there was a bit of an undercurrent in the case, in that this was what we would have then, I guess, called a complete WASP board. And the Pritzkers, of course, were the Jewish faith, and they would not have been the same charities that the individuals would have given to had they had the choice.
Did you have any sense about, I know this is all hearsay, but about, say Jay Pritzker wanting some of the directors to give to Jewish charities, about what the motivation of that was?
I think he sensed there might have been some anti-Semitism on the part of some members of the board, and that made him angry.
The case made some other surprising bedfellows.
Did you subsequently develop a relationship with Mr. Pritzker and the family and go on to represent them in other matters?
Yes, Jay Pritzker, whom I admired very much and who was very able, said to me, Bill, you will never sue me again. And I said, Mr. Pritzker, why not? He said, because I will hire you every time. And I said, well, I will give you advice so you don't get sued. And that largely happened. And I helped Mr. Pritzker on various deals.
The case also had dramatic consequences on a much broader scale. It had consequences for behavior of corporate boards.
If you think about what a board of a major corporation looks like today, and you think about this board, you'll pretty quickly understand that we were at the end of what I would call a different age. There were 5 insiders and 5 outsiders. By the time, literally a year later, when the Delaware Supreme Court decided the Unical case and made a big deal about the fact that you weren't going to get the benefit of the Unical test, only the benefit of the business judgment rule if you acted reasonably in relation to the threat posed, unless you had a majority of independent directors. You were just on the verge of having it, of in effect becoming unacceptable in a corporate governance sense to not have an independent board. And this was a split board. It was not in what we would call today an independent board.
But I think it is fair to say, looking back again, because of the era it was, is that in lieu of having a board dynamic, that's now required after Van Gorkom,
Right.
that so much turns on the mentality of the CEO and how he chose to go about things, and who he informed and when, and what he was thinking.
But if you think about today, with our special committee jurisprudence, lead directors, sometimes separate chairs of boards, we have empowered, in this type of situation, our boards substantially beyond the power that the boards had back in this era. And I think a modern board, well advised, and facing a situation like this with a CEO near retirement and arguably wanting to cash out upon retirement, would much more control the situation than was going on here,
Right.
where this was basically a passive board, and it was one of the last gasps of what I would call the imperial CEO model. And part of the lesson there is that you can't be passive. So one of the things that gets into the record here is that, well, your decision is really to let the stockholders decide, and that's one of the principles that Smith versus Van Gorkom shot down. It's no, directors are not passive. Directors have an obligation to pass on this, and you can't pass on it without a recommendation, so you have to declare its advisability using the language of 251C. And all of those things are embedded in this opinion.
And the case had sweeping consequences for merger and acquisition practice.
Even today, the Delaware law, in theory, is that you don't have to have an investment banker. In reality, you would never do one of these deals today without an investment banker. We hadn't gotten there yet. And so that's another area where you could view us sort of in transition from what I would call the pre-78 law to what we would now call the modern takeover law.
Okay. Another aspect of what's going on at the time, I believe the outside counsel is retained the day before the merger agreement is signed.
So the other way you need to look at this case is it's a Revlon case before Revlon. If you were going to sell the company, and after the Revlon decision, which was about 6 years, well, it was only a year or so later than the final decision in the Smith case, because the case dragged on through the lower court and the Supreme Court for more or less 4 to 5 years. But by the time you got to 1987 or so, you had to devise procedures designed to get the best price. Clearly, part of that would have been hiring a banker to either assist in shopping the company or at a minimum to value the company. But in 1980, none of that was yet appreciated. If you think about the facts in Smith versus Van Gorkom, if it had happened the year after Revlon was decided, it would have been an easy case, and there would have been an injunction, because literally none of the Revlon qualities were met.
So as of 1980, do you have a frame of reference to evaluate what the board?
Not a much more diluted frame of reference than you would have had after the opinion. I mean, this opinion actually formed what I would call the modern advice that you give to boards. Not only in terms of how you ought to structure your board in the first place, so that when these types of things come along, you have a majority of outside independent directors, but also the concepts that we today take for granted, that you ought to give as much notice to your board about what's going on as you can, that you ought to provide them with whatever documentation is available so that they can have it in front of them, that if necessary, you take the time to meet again if there are questions raised that can't immediately be answered. All of those questions, all of those things that we now take for granted in terms of counseling boards as to how they ought to act. That wasn't part of the culture necessarily. That's not to say that it wasn't followed in some quarters, but it was not as de rigueur as it became after this case. But I can tell you this. If I had a buyer today, or in 1987 after this case had come out, or 86 after this opinion came out, one of the things that I have told buyers would be, no, you're asking for it. You cannot push too hard. If you know what the obligations of the seller's board are, and you know that they need to take the time to make an informed decision, and you push them to a point where that's literally impossible, then think about it. If they had hired an investment banker, what kind of advice would you have gotten from an investment banker if you had hired the investment banker the day before the meeting on Saturday? So you would tell a buyer today, no, you can't possibly press this hard. You have to give the board an opportunity to consider this, to get advice, and you're asking for trouble if you overdo it.
In fact, many aspects of the culture of mergers and acquisitions had changed after the TransUnion deal was done in 1980, even before the opinion in Smith v. Van Gorkom.
Well, you see, that's part of the story of how, by the time this case finally got decided, the legal landscape was well on its way to change. There are other cases getting decided in this period also. And it didn't all just happen overnight with Smith versus Van Gorkom, the Smith versus Van Gorkom decision. The practice was evolving. The role of the lawyer in the boardroom, the role of the investment banker in the boardroom, all of these things were undergoing a revolutionary change in this period, roughly from 78 to 88, and so by the time this case got decided, you were in a different legal atmosphere than you were in at the time of the case.
For another thing, the law governing how to determine what companies are worth changed from when the merger was done to when the case was decided.
By the time this decision came out in the Delaware Supreme Court, between the time of the trial and that, the Supreme Court had clearly spoken in favor of the concept of determining intrinsic value and the use of the discounted cash flow method as being appropriate in that context, and discarded the block method. That had not happened at the time the Chancellor decided his opinion, but that you could already see, and that's just sort of one example of how when the court looks back and says, well, wait a minute, this is out of line with our existing jurisprudence, even though it wasn't at the time.
Hostile takeovers and competitive bidding for companies weren't by any means taken for granted when TransUnion was sold.
And if you step back into 1980, there was still a general sense in the what I would call the white shoe business community that we don't do hostile deals, we don't do
deal jumping?
We don't do deal jumping, and you can't think of a more white shoe company at that point in time than General Electric and General Electric Credit. So it's entirely credible that General Electric backs off and says, no, unless we'll pursue a deal, but we're not going to compete with the Pritzkers. And I don't think it would have had anything to do with the Pritzkers. I think it's more of a sense of we're just not going to get into this, something that would be viewed in the community, the business community that we live in, as deal jumping or something that, as time went on and we got to the 90s and the 2000s, all of those inhibitions about hostile deals by major companies and the like, all of that sort of faded away and went away. But this was a different age, and that was still part of the culture.
And Mr. Van Gorkom's apparent reluctance to pursue a leveraged buyout of TransUnion, in which its younger executives might participate on the buy side, was perhaps a product of a time gone by, perhaps even by 1985.
The opinion suggests that he wasn't enthusiastic about a leveraged buyout. I think he truly believed that leveraged buyouts were inappropriate, and as did many other people in the 70s. And it wasn't until the Wells-Rich case in the SEC and then in some other cases that the tide began to turn. But at this point in time, leveraged buyouts were not only new, but some thought they were immoral and just not appropriate to have, especially management leveraged buyouts, MBOs.
Finally, the TransUnion case is said to have led directly to the enactment of Section 102B7 of the Delaware General Corporation Law, permitting the now nearly ubiquitous charter provisions that preclude director monetary liability for breach of the duty of care.
Well, 102B7 basically came out of Smith v. Van Gorkom.
Right.
It was a reaction to it. And the idea that, because after the Supreme Court's opinion came out, then the question was, were these directors going to be personally liable? There was an effort to get the corporate defendants out, and you had a question of would there be sufficient insurance, and would the directors have sufficient assets to satisfy any judgment? And ultimately, Bill concluded that if you were going to settle the case, you really had to settle it with Jay Pritzker.
And settle the case they did. The two main protagonists in the TransUnion deal died within a year of each other, in March 1998 and in January of 1999. The consequences of the case that emerged from the merger they put together have continued long after that.